So I used to get this question a ton when I was working in law school admissions. I'd have an applicant come into my office or call me, "Can I go to law school if I've been arrested? Do I have to give up my dreams of becoming an attorney because I have a criminal record?" And if you found yourself wondering the same thing as you start your application journey, I hope this video is helpful. My name is Alice Foley, and I'm an associate law school consultant with Montgomery Admissions Consulting, where we specialize in first-generation and minority law school application support. I come to consulting with nearly a decade of experience in law school admissions, and I have done everything from answering basic law school application questions, talking about what law school is like, to sitting on the admissions committee and reading applications for decision. I really have done a lot at this point, and I'm more than happy to share that experience with you today. So in this video, we're going to cover some of the basics about how you would apply to law school and what it's going to look like as you apply to law school if you have been arrested or you've got a criminal record. Typically, this comes up as a concern for the character and fitness disclosures that are going to show up on your law school application. And the good news is, the short answer to that question is that having a criminal record will typically not bar you from becoming an attorney or going to law school. At the end of the day, however, it is going to be applicant specific. It's going to be case by case. So there are always exceptions, and my best advice is to make sure that you know what you're doing as you start filling out your application. And if you have questions, ask. So the first thing that we're going to cover is why this is even a concern for you as an applicant and why the law schools are concerned about this. So we're going to start with why it's a concern for you as an applicant. Why does it even matter if you've got a criminal record? And the reason is that almost every law school application, if not all of them, have a part of their application that's called the character and fitness questions. They are typically touching on a variety of subjects. And what we're going to cover today is a question that will likely read something along the lines of this. Are you currently under indictment, or have you ever been convicted, placed on probation, or given a deferred adjudication or diversion program for a criminal offense? Have you ever been arrested or cited for a criminal violation? The language of this question will likely vary a bit law school to law school, but at the heart of the question, they want to know if you've got a criminal record. Now, why do they want to know this? There's a lot of reasons, and there are probably some that are coming to your mind right now, and chances are those are probably right. The ones that I'm concerned with, and the ones that may not be as obvious to you, are why an admissions committee is concerned. And a lot of what an admissions committee is doing is, yes, they're reading applications for decision, of course. They want to see if a student is going to be successful. Admissions committees are not in the business of trying to admit students that they know are not going to be successful. So if there's a question about that, there becomes a question about their admissions decision. Sometimes character and fitness disclosures can bring up that question. The reason is that we, as an admissions committee, don't want to put you in the position of having spent 3 years of your life, very likely a lot of money, to graduate with a law degree that you may never be able to use in practice. If you can't be admitted to the state bar in the jurisdiction where you want to practice, I'm not going to say you've wasted your 3 years, because there are plenty of other things that you can do. But if you wanted to be an attorney and you don't find out until after you graduate law school that you can't, that's awful. And admissions committee members don't want to do that to any of their applicants. There are real humans back there, and they're typically nice humans. They want you in their law school if they think you're going to succeed. So if you've been admitted, they think you're going to succeed, right? The other major consideration is that it goes into this. When you apply to the state bar for your license to practice law as an attorney, they are more than likely going to ask you for your law school application. And at this point, all of this is on the honor system. The law school is not going to run a background check. We are hoping that you are honest as an applicant. I'll touch a little more on that later, because if you hadn't gathered, the state bar is absolutely going to run a background check. So the next thing that we're going to cover is, how do you answer those questions? The short answer for me is carefully and completely. I want you to read those questions carefully. You will likely at some point in time hear this from me again, but if you take nothing else away from any experience that you have had chatting with me or watching these videos or anything along those lines, it's that I need you to read the directions carefully. Read your instructions carefully. Read the questions that you are asked carefully. This is a little down-low test for you as a law school applicant, okay? If you cannot read and follow directions in the law school application, what on earth is going to make me think that you will read the directions and follow instructions and, read a contract carefully when it comes time for you to be negotiating contracts, or reading a deposition carefully when you are working for one of your clients later on. Read the directions or the instructions carefully. The reason I say this in this context is that some law schools are going to ask for very specific things. They may only want to know anything on your criminal record from the last 5 years. They may also only want to know things that weren't sealed or expunged. If something happened when you were a minor, they may not want to know about it. The one that came up the most for me is parking tickets. Y'all, I don't care how many parking tickets you have. I do not. Neither of the law schools that I worked for cared. The only type of vehicle violation that we were interested in was if it involved moving violations. If you were caught speeding, if you were in an accident and it was cited, then we want to know about it. But y'all, I do not care how many parking tickets you have. Look, if I had to disclose how many parking tickets I had when I applied to law school, we would probably still be here. I do not like to feed that meter. I will pay my parking ticket as soon as I get it, but I'm not going to dig around for change if I don't know exactly where it is. I'm just not going to do it. Don't be like me. Don't get a bunch of parking tickets. But for real, if you are confused about what a question is asking, if you are not sure if you should disclose something, please contact the admissions office and ask. They are not trying to hide the ball for you here. They want you to answer the question carefully and completely too. So if you are confused or you are unsure, they will help you. I wish so many more applicants had called me while I was doing this and just asked if they needed to add their parking tickets. It would have saved me so much time. Some schools are going to ask for your parking tickets. Do not take that as gospel. Read the question carefully. You do not need to tell them any more than what they are asking for. So once you have a good handle on what it is that you need to disclose, you're going to find that when you check yes to any of those boxes in the character and fitness questions, because they are typically yes or no checkboxes, when you check yes, you're going to be asked to provide some information, some documentation. The normal things are going to be any court documents, any related documents along those lines. If you have them, wonderful. If it's a serious offense, look for them. If it's something simple, if it's older, as long as you can give us the main details, it's fine. On the details, try to answer it completely. At minimum, and honestly sometimes at maximum, what we need as an admissions committee for any of these disclosures that you need to explain are the date and time of when it happened, the location of where it happened, what factually happened. I don't care about your emotions right now. I don't care about your feelings in this moment. I just need to know what specifically factually happened. There's time for your feelings later. And then the outcome. Were you charged? Were you arrested? Did you pay a fine? What happened? The reason I want to be very clear on what details we do want and what details we do not need is because in this place where you are adding these documents, you pretty much have free reign. You can write whatever your little heart wants. But I will tell you, this is not the time for a very flowery story. Again, now is not the time for your feelings. We need to know what happened. We need to know the outcome. We need those details. One of the most common things that I saw that, well, it typically would not make or break an admissions decision, but certainly did not help, was someone who over-explained a minor infraction. If the only run-in you have ever had was a speeding ticket, I understand that that may seem very big to you. In the grand scheme of things, unless, it was fast enough that you were being bumped up to a misdemeanor or a felony charge, although I don't think there's a way to speed fast enough for it to become a felony. But you get what I'm saying here. If it's just a regular old run-of-the-mill speeding ticket, I do not need a thesis on what you have learned since. I need to know where you were, ideally how fast you were going and what the speed limit was. That's those factual details. And what happened at the end of it. Did you pay your fine? Did you have to go to traffic school? That's all I need. If you can, in one sentence, give me context, that's fine. But typically it is not necessary for minor offenses. If you did in fact learn something, that is wonderful, and I'm glad. You should learn something. You should not do it again. But I don't need you to tell me about it. Not here. This is not the place for that. However, As with most things, there are exceptions to this. If instead of 1 speeding ticket, it's 1 a month for a year and a half, that's a bigger issue. Please tell me more. I need more context there. If the offense on its own was considered very serious, I would like a little more context. If you were picked up for public intoxication or underage drinking in your first or second year of college, I do not need 2 pages about what you've learned and the dangers of alcohol and how you have not touched a drop since. However, if it is a pattern, I'm gonna want more details. I'm gonna want more information because that tells me there's something bigger happening. If it's 1 and that was the end of it, time, place, what happened? If you have questions about whether or not you should share something in a disclosure, or if you are not sure whether or not you are giving too much information or too little information, this should also come as no surprise. Call the admissions office and ask. If you are comfortable with your admissions officers, and it's okay if you are not, but if you are comfortable with your admissions officers, you can call them right up, run down the specifics with them, and they can give you a pretty good answer about what they're going to want to see. At the end of all of it, what happens if you don't provide enough information is that the admissions committee is going to hold your file sometimes. They may ask you for more information, and it's just going to delay your decision, and nobody wants that. We want you getting those decisions as soon as possible. We want to start celebrating as soon as possible that you've been admitted to law school. What happens when you over-explain is that inevitably, and not on purpose most of the time, it starts to sound defensive. You start to blame shift. And I know that it's not on purpose, I get that. It just happens when you hit the end of the page for a minor offense, because you've run out of things to say. So be intentional with your language. These should be a paragraph, maybe 2, unless it is a very serious offense, or like I said, there is a pattern of behavior. And at the end of the day, if you have questions at the end of all of this, ask your admissions officers. These things will vary school to school. You need to talk to them if you have questions. Now, the last thing that we're going to talk about is something that I started with. Why do you need to take this seriously if the law school isn't running a background check? How are they going to know if you leave something out? And that's a really great question. And technically they won't. I will say, don't take this as gospel. There is typically a checkbox or something that you electronically sign before you submit your application that says, to the best of my knowledge, the information that I have provided is correct, complete, and accurate. It's a thing that you will have to sign. It's not a great idea to start that off with lying. The other reason, and quite honestly the more important reason, is that after you press submit and you've been accepted and you're starting law school, you're not done with character and fitness questions. They're going to show back up on the state bar, and they're going to be a lot more detailed, more than likely. And the state bar is absolutely going to run a background check. So, this brings a couple of things together. I talked earlier, your law school application is going to become part of your bar application. The state bar is going to run a background check. You better believe they're going to compare the 2 when all of that is done. So if something shows up on your background check that didn't show up in your law school application, quite honestly, that is a bigger red flag than it showing up. If you have legitimately forgotten something, it's okay, it's not the end of the world, don't panic. You can typically amend your application through law school, and this happens a couple of different ways. If something happens during law school that falls into these categories, you may have to amend your application. That is going to be a state-by-state thing, so check with your law school folks, they're going to know. This time I'm not going to say check with admissions, because they typically don't handle this after you've enrolled. At this point, you're going to want to talk to either your bar success people or your dean of students or someone that works in the student affairs or the student life office. If they don't know the specific answer, they're going to be able to point you to who can help you. So at the end of the day, after all of this, the answer, like I said earlier, for can I go to law school if I've been arrested or I have a criminal record is always going to be it depends. We've covered some of the reasons why this is even a question for future lawyers. We've talked about how you should answer these questions when it comes time to answer them in your law school application, and why you shouldn't intentionally leave things out even though the law schools don't check. I do want to leave a quick note. I mentioned it really briefly at the beginning. There are many, many, many successful attorneys that were arrested before they applied to law school or spent time in jail before they went to law school. There are some that have even gone on to receive MacArthur Genius Grants and become award-winning authors. Law schools at this point are evaluating the importance of character and fitness questions, specifically with regard to criminal histories. The landscape here is changing, and who knows what's going to be asked of your application or how important it'll be going forward. So for now, make sure you read the questions carefully. I hope this has been helpful. If it has, please like and subscribe. If you think of a friend that this may be beneficial to, please share it with them.